Hello. Welcome to Bear Paw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bear Paw Media and Education is a department of Native Counselling Services of Alberta, and our primary goals are to make public legal education understandable, accessible, and affordable for Indigenous people. We at Bear Paw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities, and is edited by lawyers. Of course, laws change with elections and societal values, so this information is designed to be general in nature and may not apply to your specific situation. It may still be necessary to consult a lawyer for legal advice to assist you. For more information, you can go to our website at bearpawlegalresources.ca or follow us on social media at Bear Paw Legal. I'd like to begin by acknowledging that the land in which we gather is Treaty 6 territory and a traditional meeting ground and home for many Indigenous people, including the Cree, Saulteaux, Blackfoot, Métis, and Nakota Sioux. Today's topic is going to be on the new impaired driving laws. And so I'd like to start with a video that we created through Bear Paw Media. And you will always be able to access any of our resources, including this video, on our website, bearpawlegalresources.ca, available for viewing for free at any time.
Hi, I'm Michaela Shannon.
And I'm Nathan Alexis. Have you ever been out with some friends for a night out to town, had a few drinks, a few hoots, and thought, nah, I'm good to drive? Well, it's time to rethink what it means to be impaired.
Impaired can mean many things nowadays, and it's not just limited to alcohol. This can include cannabis and illegal drugs like cocaine, meth, ketamine, and shrooms, as well as legal drugs, medical issues, and lack of sleep. Saving lives is number one because 4 people are killed and 175 are injured every day in impaired driving crashes.
This is a non-judgment zone, and we want to be frank and discuss with you what can happen when you operate a motor vehicle with any of these substances in your body.
In Alberta, there are different laws regarding impairment for those of you who have a graduated driver's license, also known as a GDL.
Alberta has a zero-tolerance policy for GDL drivers. This means no alcohol, no cannabis, no illegal drugs in your bloodstream. If you test positive, you'll face an immediate 30-day suspension and a 7-day vehicle seizure. You'll also be required to complete an additional year in the GDL program.
We invited police officer Heather Noon and scientist Dr. Leafy to answer your questions. Ask your questions using the hashtag #AskAboutImpaired Driving Laws.
Officer, doctor, thank you for joining us.
Not a problem. Thank you for inviting me to the conversation.
Looking forward to taking questions.
Constable Noon, can you tell us the impaired driving trends of young people today?
Yes, we've seen an increase in impaired driving with both drugs and alcohol offenses. We want new drivers and youth to be safe and have all the facts so they can make the safest decision when they get behind the wheel.
We have our first question for Dr. Leafy. What effects can drugs and alcohol have on drivers?
With alcohol, it slows your reaction time. You'll have lack of coordination, reduced concentration, decreased vision, and alcohol can inhibit your judgment. With cannabis, it affects your ability to make good and quick decisions. This means a reduced ability to divide attention, poor time and space perception, and difficulty concentrating. In all cases, driving impaired is incredibly dangerous. Incredibly dangerous.
We want you to be armed with the facts. Even though cannabis is still legal, there is still a specific range to how much you can have in your body when you're driving.
This is important because there are many ways to use cannabis: smoking, oils, and edibles, all which can impact your body in different ways.
Safety for the driver, the people in the car, and the general public is number one.
Hello, how you doing tonight? Good, I'll bring the checks up. Just here to check your sobriety tonight, okay?
Okay. Constable Noon, could you walk us through a roadside stop?
If we suspect that a driver is intoxicated by either drugs or alcohol, you will be pulled over. A police officer will approach the vehicle and ask for your license, registration, and insurance, and then ask if you have consumed any alcohol or drugs.
What if the driver says they didn't consume alcohol or drugs?
Well, there are many tools we use to determine if someone is intoxicated. We just don't take your word for it. If we have a reasonable suspicion you have any drugs or alcohol in your body, we can administrate a roadside test.
What kind of tests are used?
You will be asked to blow into a roadside screening device. The device determines if there's any alcohol in your breath. This device cannot determine the amount of alcohol in your blood. That can be determined by a blood test.
During a roadside screening test, your right to contact a lawyer is suspended. However, if you are arrested, you do have the right to contact a lawyer.
If you refuse to blow into a roadside screening device, this is an automatic criminal offense, and you will be charged with a refusal to provide a sample. The penalty is the same as getting an impaired charge.
But if you are certain that the results are wrong, you can ask to blow again. This is a roadside appeal. The only caution is that if you do have alcohol in your system, it may appear higher on the second breathalyzer test because your body took longer to absorb the alcohol.
If you consumed any alcohol, it's always best to just call an Uber, taxi, or your mom. Sorry. Yeah? Hey, Mom, what's up?
Perfect, just like that.
Constable Noon, what would happen if you blow between 0.05 and 0.08 grams on the roadside test?
In Alberta, we have provincial penalties called Immediate Roadside Sanctions and are not considered criminal charges under the criminal code. If you blow between 50 and 80 milligrams and it is your first offense, you'll receive an immediate 3-day driving suspension or more and a 3-day or longer vehicle seizure. You pay the cost of towing and impound charges on your vehicle. This will show up on your driver's abstract.
Dr. Leafy, thoughts?
Yes. The penalties on a driver's abstract are exponentially terrible, possibly affecting your reputation, employment, and transportation.
I'm going to get you to come out to the car and I'm going to do some standardized field sobriety tests, okay? So we're just going to get you to stand on the side of the road and walk on the line for me and stand on one leg. Really, really easy stuff, okay?
Okay.
So I need you to look at the top of the pen, take 9 heel-to-toe steps down, turn around and take 9 heel-to-toe steps back, okay?
When stopped by the police, if you blow over 80 milligrams of alcohol, you will be charged under the Criminal Code of Canada. You will receive an immediate 3-day vehicle seizure and an automatic 90-day driving suspension where you'll not be allowed to drive under any circumstances. If proven guilty in court, you'll receive a 1-year or more driving suspension, a $1,000 or more fine, and you'll have to enroll in the mandatory ignition interlock program. If you choose not to participate in the ignition interlock program or can't afford it, you will remain suspended with no ability to drive legally.
I do smell the odor of burnt cannabis inside the vehicle, though. I'm going to get you to provide a sample of your oral fluid into a screening device in my vehicle. Do you understand?
What if you are pulled over and are suspected of cannabis use?
Well, if you're suspected of using drugs, we would use a standardized field sobriety test, then use an oral fluid device. If we have reasonable grounds to believe you are impaired by drugs, you will be tested by a drug recognition expert, also known as a DRE, and we can demand a blood test. Your car will automatically be impounded.
Impounded at your cost, FYI. The impoundment fees can be very, very freaking expensive.
That's correct. And then you may be taken to the police station or hospital to do a blood test.
What if the driver doesn't comply, either by not doing the test or is refusing to go to the police station?
You will be arrested and charged under the criminal code with refusal to provide a sample.
Brutal.
Our main concern is for the safety of the driver and the citizens on the road.
We are now going into our lightning round called Myth or Truth. You can wait in your vehicle without driving until you are no longer impaired. Myth or truth?
Myth.
Correct. If the vehicle is not in motion, you can still be charged for being impaired because you could potentially set the car in motion. Next question. Police need a reason to pull you over.
Truth.
Correct. Truth. However, if it is unclear, you can ask what the reason is. You ready for the last question? You can drink energy drinks and eat a big meal to sober up.
Truth.
Myth. There are no tricks to speed up the elimination of alcohol. Only time works. Taking a cold shower, drinking strong coffee, going for a run, or dancing will not lessen the effects of alcohol. To sober up, you have to wait for your liver to do its work. Thanks for playing Myth or Truth.
Looks like we have time for one last question for Dr. Leafy. What are the new legal limits of cannabis impairment?
The prohibited concentration of drugs in the bloodstream within 2 hours of driving are between 2 and 5 nanograms of THC. If proven guilty, the maximum fine is $1,000. For 5 nanograms or more of THC, the mandatory minimum for your first offense is $1,000. After your second offense, jail time.
What are the limits of the different combinations of alcohol and cannabis?
For a combination of 50 milligrams of alcohol and 2.5 nanograms or more of THC, the mandatory minimum for your first offense is $1,000. And after your second offense, jail time.
Wow, steep fines. And this law applies to people with medical authorization for cannabis use too?
Correct.
This is some complicated stuff, but it's important to know so you can make the most informed decision. Just call a Lyft or Uber when you need to hit that drive-thru for those late-night cheeseburgers. If you do end up getting a DUI, going through the court process is very important. You have to attend all the court appearances, you have to follow all the conditions, you must pay all the fines. You want to avoid any penalties that would just add more costs and charges.
There are different penalties for varying amounts of impairment, but zero drugs and alcohol when you get behind the wheel is the safest for everyone.
If you do drive impaired, you could face a life sentence in jail, or worse, you could take someone's life.
You need to make the call. Call your family, your friends, a cab, an Uber, or stay the night. Err on the side of caution. We know you can do it. Be smart, be safe, and stay alive.
So on April 13th, 2017, the Government of Canada introduced the most comprehensive reform to the Criminal Code transportation regime in more than 40 years, including to drug and alcohol impaired driving. The reforms created a new, modern, simplified, and more coherent system to better deter and detect drug and alcohol impaired driving. The Government of Canada is committed to deterring impaired driving in order to keep Canadians, our roads, and our communities safe, and ultimately save lives. The bill was passed by Parliament on June 20th, 2018, and received royal assent on June 21st. It's important to note that provinces and territories also have additional laws or regulations that may apply. Impaired driving is the leading criminal cause of death and injury in Canada. In 2015, there were more than 72,000 impaired driving incidents, including almost 3,000 drug-impaired driving incidents. Drivers under the Graduated Driver's License Program in Alberta found to have any amount of cannabis or illegal drugs in their blood are now subject to the same provincial sanctions that apply to alcohol, including an immediate 30-day license suspension, an immediate 7-day vehicle seizure, and they must remain in the Graduated Driver's License Program for 2 years with a full 1 year of suspension-free driving time. And so at any point during that 2 years, especially in that last year, if a driver is caught with any amount of alcohol or drugs in their system while driving, it will extend their term in the Graduated Driver's License Program. Graduated drivers who meet the requirements for criminal level impaired driving will also be subject to any and all provincial sanctions as well as criminal penalties that may apply. Not sure if you've heard, but in Canada, marijuana is legal. However, it is still illegal to have consumed more than 2 nanograms of THC per milliliter of blood within 2 hours of driving. This also applies for any detectable levels of other impairing drugs, including cocaine, methamphetamines, LSD, 6-mem or a metabolite of heroin, ketamine, magic mushrooms. The law also applies to those with medical authorization for cannabis. Scientific advice indicates that these drugs are incompatible with safe driving at any level. As well, the level for GHB is 5 milligrams per liter, as the body can naturally produce low levels of this drug, and as such, a blood drug concentration of any detectable level would not be appropriate for that drug. Other terms for magic mushrooms include phencyclidine, psilocybin, and psilocin. The new legislation was designed to make detecting drug-impaired driving easier by authorizing the following. If the police believe that a driver has a drug in their body, they may demand an oral fluid sample to test for drugs at the roadside, so a swab in the mouth. If they believe that an offense has been committed, such as a positive roadside test, together with other observable factors, police may pursue drug recognition evaluation or take a blood sample. Police officers trained in drug recognition and evaluation, DRE, are able to provide opinion evidence in court to the level a driver is drug impaired, without the need to qualify themselves as expert witnesses in each trial. Where an evaluating officer has identified a drug type as impairing a driver at the time of testing and is confirmed by analysis to be in the driver's body, it would be presumed that the drug was causing the impairment at the time of the driving. There are approved tests that can be conducted and the procedures to be followed during an evaluation, which include a preliminary examination, which consists of measuring the pulse and determining that the pupils are the same size and that the eyes track an object equally. It's almost going to sound like you are going to be getting a roadside medical exam, and it would appear so. An eye examination a divided attention test, an examination which consists of measuring the blood pressure, temperature, and pulse. Also included in the testing is an examination of pupil size under different light levels, ambient light, near total darkness, and direct light, as well as an examination of the nasal and oral cavities. An examination which consists of checking the muscle tone and pulse, and a visual examination of the arms, necks, and, well, neck, and if exposed, the legs for evidence of injection sites. Physical testing for the presence and impairment of drugs in Canada is accomplished through the standardized field sobriety tests and drug recognition evaluations. The SFST forms an integral part of the DRE testing, but is to be used only for screening in Canada, whereas the DRE is to be used as evidence at a trial. A useful way of considering them is that the SFST, the Standardized Field Sobriety Test, acts like an approved screening device to provide grounds for an arrest, while the DRE is more akin, evidentially at least, to the approved instrument, only justifiable if reasonable and probable grounds exist. So there needs to be more observable facts, but then for the purpose of proving the charge before the courts. So the DRE is more observable, roadside, but the standardized field sobriety test would also be required in order to lay charges. The oral fluid screener is the equipment that detects the presence of some drugs in saliva, spit, which is collected from the driver. The equipment indicates the presence or absence of drugs. These devices are fast, non-invasive, and can accurately detect THC, cocaine, and methamphetamine, which are the three most common impairing drugs found in Canadian drivers. Police can demand an oral fluid sample if the officer has a reasonable suspicion that the driver has drugs in their body based on objectable, observable, visible facts, such as red eyes, muscle tremors, agitation, and speech pattern. If a driver tests positive on an oral fluid screening test, the positive result would confirm the presence of the drug and, combined with other signs of impairment observed by the police at the roadside, would provide grounds for the investigation to proceed further, either by making a demand for DRE or a blood sample. And so these are the new, the current charge structures or sentencing structures for penalties for drug impaired driving. If a person is found guilty of having 2 nanograms but less than 5 nanograms of THC per milliliter of blood, they will be fined a maximum of $1,000. If they are convicted of having 5 nanograms or more of THC per milliliter of blood, or any detectable level of LSD, psilocybin, psilocin, ketamine, PCP, cocaine, methamphetamine, or 6-mem, or 5 milligrams per liter of GHB, we're now on a sentencing step-up program, I guess. With the first offense, there's a mandatory minimum $1,000 fine. And unlike sentencings of years gone by, Now, under the new drug impaired driving sentencing structure, with the second offense, it is a mandatory minimum of 30 days in jail. That means that judges don't have a choice anymore. If somebody is facing their second offense of drug impaired driving, they are automatically looking at minimum 30 days in jail, if not longer. And then for third and subsequent offenses, it's a mandatory minimum of 120 days, essentially 4 months, in jail. And that, again, is a mandatory minimum. It could be longer. Those same mandatory minimums apply if anybody has been found guilty of having 50 milligrams of alcohol plus 2.5 milligrams or more of THC per milliliter of blood. And so it also applies with a combined of alcohol and THC. The penalties for traffic offenses, driving offenses, causing bodily harm, and beyond have also gone up extensively as well. So if someone's been charged with drug impaired driving that does not cause bodily harm or death, so you took out the neighbor's fence, that would be classified likely as a summary conviction, and you could be looking at a maximum of 18 months in jail. Now, if it was an indictable offense, so probably even though you didn't cause bodily harm or death, but you drove through a storefront, you hit the gas pedal instead of the brakes, that would likely be an indictable conviction, and someone could be looking at up to 5 years in jail. And so, you're looking at very likely spending jail time for doing property damage as a result of drug impaired driving. Now, if someone was found guilty of drug impaired driving causing bodily harm, the maximum penalty, 10 years in jail. And drug impaired driving causing death, the maximum penalty is life. Police can demand that a driver comply with either a standardized field sobriety test or provide an oral fluid sample if they have reasonable suspicion that a drug is in a driver's body. So in order for the police to demand a roadside test for drugs, they have to have observable evidence. So, the red eyes, the slurred speeches, the jittery movement, maybe track marks, needle injection sites visible on arms, neck, legs if exposed, those kinds of things. If they have reasonable grounds to believe that an offense has been committed, they can demand a blood sample or a drug recognition evaluation. Some key elements of the new impaired driving laws because of alcohol. Now, there's been some extremely significant changes to the alcohol impaired driving laws, and they include authorizing mandatory alcohol screening to make it easier to detect whether a driver is impaired. Part 2 of the new impaired driving legislation significantly reforms the entire criminal code regime dealing with transportation offenses, including alcohol impaired driving. Bill C-46 came into force on December 18th, 2018. It eliminated some defenses that encourage risk-taking behavior, making it easier to prove blood alcohol concentration for some impaired driving offenses, and clarifying what information the Crown is required to disclose to prove blood alcohol concentration. Under the new laws, police officers who have an approved screening device on hand would be able to test a breath sample of any driver they lawfully stop. Let me repeat this. Any police officer who has an approved screening device on hand would be able to test a breath sample of any driver they lawfully stop, even without reasonable suspicion that the driver has recently consumed alcohol. So if you get pulled over for speeding or for swerving a pothole, or for no seatbelt, as long as an officer lawfully pulls a person over, has a lawful reason for pulling someone over, they can demand a roadside breath sample. This would be done after the person has been lawfully stopped. A driver who refused to provide a breath sample at this point would be subject to a criminal offense. They would likely be charged for failing to provide a sample. Drivers do not have the right to contact a lawyer before the roadside test. Do you remember that lovely thing called the Canadian Charter of Rights and Freedoms, or the Constitution, that says that we're all innocent until proven guilty, or also that you are all entitled to consult a lawyer before giving evidence? Where impaired driving laws are concerned, that's not the case anymore. Under the previous law, police officers had to have reasonable suspicion that a driver had alcohol in their body before doing any roadside testing. Research suggests that up to 50%, so 1 in every 2 drivers with a blood alcohol concentration above the legal limit, are not detected at roadside check stops. Mandatory alcohol screening will assist in deterring individuals impaired by alcohol from driving, as well as better detect those who do. It is currently authorized in over 40 countries worldwide, including Australia, New Zealand, Austria, Belgium, Denmark, Finland, France, Germany, Ireland, the Netherlands, and Sweden. Authorities in Ireland credit mandatory screening, reducing the number of deaths on Irish roads by approximately 40% in the first 4 years after it was enacted. So there is justifiable reasons for the change in the impaired driving roadside screening. It'll certainly be interesting to see how it all plays out in court with any charter arguments. The approved alcohol screening device is the roadside breathalyzer device, which are devices used by the police to measure your blood alcohol concentration from a breath sample. The 2 most common devices used in Canada are the Alcosur and the AlcoSensor. These machines do not actually measure your blood alcohol directly, but instead estimate it indirectly by measuring the amount of alcohol on your breath, which may then register a fail result. If you fail the roadside test, police can demand formal breath or blood test at the police station or a mobile testing unit. There must be at least 2 samples taken 15 minutes apart. If a physical condition prevents a breath sample, the officer can demand a blood sample, which then must be taken by a qualified medical practitioner. The driver must provide informed consent or get one from a judge if the driver's not able to give it, whether they're injured or unconscious. Again, you do, at this point, even though you did not have the right to consult a lawyer prior to the roadside test, If you fail the roadside test and you are taken to the police station or a mobile testing unit, at that point, you now do have the right to contact a lawyer before screening at the mobile testing unit or the police station. So again, just to clarify, you do not have the right to consult a lawyer before the roadside screening test. But if you fail that test and you're taken to the detachment or a mobile testing unit and asked to provide the 2 formal breath or blood tests, at that point, you do have the right to contact a lawyer before providing that screening. You also have the right to appeal the roadside test, but keep in mind that you may actually test higher the second time, as your body will have had time to absorb even more alcohol. So how do the police test for blood alcohol content? Police use breathalyzer devices to measure the amount of alcohol in your breath. The roadside screening breathalyzer rates your blood alcohol content in one of 3 categories: a pass, under 0.05%. You may get a warn, which means that someone has registered 0.05 to 0.08, or a fail, which is 0.08 or higher. So the roadside screening breathalyzer actually only provides a pass, warn, or fail. Drivers in the warn range can face immediate roadside suspensions and other sanctions under the provincial or territorial administrative programs, and I will talk more about that shortly. Drivers in the fail range may be required to go to a police station to be tested on a more sophisticated breath testing device, which provides an actual blood alcohol content level reading. As of December 1st, 2020, when an officer has reasonable grounds to believe that a driver has committed an impaired offense, the driver will be issued an administrative penalty called the Immediate Roadside Sanction fail, receive an immediate 15-month driver's license suspension, receives a 30-day vehicle seizure, be issued a $1,000 fine, be required to complete mandatory impaired driving education. If they're a repeat offender or there's bodily harm or injury, they receive an escalating administrative penalty and will be criminally charged with an impaired offense. A driver can drive again after 3 months if they install an ignition interlock device. And if the driver chooses not to participate in the ignition interlock program, they will remain suspended with no ability to drive for the full term. So this is the immediate roadside sanction, which means that people could be charged, but remember, we're all innocent until proven guilty. Not the case with impaired driving. When somebody is charged with impaired driving, they haven't been proven guilty. They're still waiting for their day in court. But while they're waiting to be found guilty, they still wind up having their license suspended. Their vehicle is seized and towed. They're issued a $1,000 fine. There's mandatory impaired driver's education before they're ever able to even think about getting their license back. And it escalates at that point. If they want to drive after the 3-month mandatory suspension, they would have to apply for and pay for the ignition interlock program. And so innocent until proven guilty, maybe, unless you're dealing with an impaired charge. If a driver wishes to dispute their notice, they will access the website and pay the fine. So if you If you want to dispute your notice, you now access a website. So it means that processing impaired driving charges happen a lot faster because you no longer have to wait to go to court. So you access the website and you can pay the fine, request time to pay, or request a review of the sanction. You can attend an oral review either by phone or video, which will be scheduled within 21 days of being charged, or you can submit a request a written review. Receive the written decision within 30 days of the issuance of the notice. And so things happen very quickly now in Alberta. Impaired driving charges no longer go through the mainstream court process, but they're all processed online. If the driver is unsatisfied, they may also seek judicial review at the Court of Queen's Bench of Alberta. So roadside sanctions between 0.05 and 0.08. With the first offense, there's the immediate 3-day license suspension and 3-day vehicle seizure. Now, this isn't being criminally charged. This means that you have blown a warning. So you've tested a warn between 0.05 and 0.08 on the roadside sanction. Your first offense, your license is immediately suspended for 3 days, and your vehicle is seized and towed for 3 days. I sure hope that wasn't your mom and dad's vehicle, because you're going to be in a lot of trouble when you get home. With the second offense within a 10-year period, it's an immediate 15-day license suspension, a 7-day vehicle seizure, and attendance to the Crossroads or Planning Ahead course, which all costs money. And with a third offense within a 10-year period, it's an immediate 30-day license suspension, 7-day vehicle seizure, and the impact course. So remember that you haven't committed a criminal offense, so you're not being criminally charged, but because you have you've blown the warn between the 0.05 and 0.08, you're going to be penalized with these measures. The Mandatory Ignition Interlock Program is a mandatory program for individuals who have been criminally convicted of an impaired driving offense in Alberta and who must comply with the Mandatory Ignition Interlock Program to satisfy their reinstatement conditions. Drivers must demonstrate a sustained ability to separate drinking and driving behaviors by completing the Mandatory Ignition Interlock Program and obtaining a full and unrestricted driver's license. Please note that refusal or failure to provide a breath sample will continue to result in an Alberta administrative license suspension and criminal charges. Now, you can appeal the Alberta administrative license suspension, but they don't make it easy. The information on the back of the notice of suspension disqualification form guides a driver through the appeal process, which is conducted by the Alberta Transportation Safety Board. Applications for hearings are $125 for a written hearing or $250 for an in-person hearing. Alberta registry agents may also charge a service fee. To appeal the vehicle seizure is a separate appeal process altogether. The registered owner of the vehicle or any third party authorized by the registered owner may apply for early release of the vehicle. Applications are available at any Alberta registry agent and must be submitted to the board. Appeal application costs are the same. There's a 30-day limitation period to make an appeal to the board. All seizures can be appealed to Alberta Transportation and Safety Association and must pay an application fee for Alberta Transportation and Safety hearing, as well as towing and impound fees. For further information on the appeal process, please contact the board, or to purchase an application for hearing, please visit any authorized Alberta registry agent. The grounds to appeal the suspension under Section 39.2 of the Traffic Safety Act are if the person did not drive, having consumed alcohol, drugs, or combination in a quantity to impair operation of the vehicle at any time within 3 hours of driving, or the person did not drive having consumed alcohol in a quantity such that the person's blood alcohol concentration level was 80 milligrams or over at any time within 3 hours of driving, or the person did not fail or refuse to comply with a breath demand, and if they did, they had a reasonable excuse. So again, they don't make it easy, and it is costly to appeal. Once convicted of impaired driving, offenders may apply for the Provincial Interlock Program at their own expense, but there is now a wait time imposed. And the wait time is a minimum of 3 months or longer, depending on how many prior offenses a person has. The costs of Interlock program include the program application is $63. To install the device, $145. Plus, there is a monthly rental of $95 per month. There's also an application for a restricted driver's license. I'm not sure what that is. It probably varies with the privatization of registries. The interlock device removal, so you've now finished your interlock program and you have got your full license back. You're going to have to pay $50 to have the device removed. If it's your first offense, you're going to have to attend a planning ahead course, and that costs $315. For a second and subsequent offense, you'll have to attend an impact course, and that's $925. So an impaired driving charge has a lot of hidden costs. Under the previous law, drivers could argue that alcohol that they drank just before driving was not fully absorbed, and so they were not over the limit when they were driving. This is known as the bolus drinking defense. The new law removes this defense by making it illegal to be over the offense level within 2 hours of driving. A driver could claim they consumed alcohol after driving, but before testing. They could claim that this alcohol is what put them over the limit at the time of testing, and that they were not over the limit while they were actually driving. The new law only allows this defense in a situation where a driver drank after driving and had no reason to expect a demand by the police for breath testing. The new law clarifies what evidence the prosecution has to provide the defense about breath testing conducted at the police station. The prosecution will only be required to disclose information that is scientifically relevant, such as the result of calibration checks and any error messages produced by the testing instruments. The defense can apply for further disclosure relating to breath testing, but the court would first need to be satisfied that the requested material is relevant. So when we're looking at the penalties for impaired driving, these have gone up substantially as well. So for a person, and it not only goes by first, second, and third and subsequent offenses, but they also break it down in to blood alcohol content as well. And so with first offense, there's 4 levels or 4 classifications of first offense impaired driving. If someone was charged with their first offense of impaired driving, and their blood alcohol content was between 80 and 119 milligrams of so 0.08 to 1.19, then it's a mandatory minimum $1,000 fine. If they've been charged with their first offense and that blood alcohol content is 0.120 to 0.159, they are looking at a mandatory minimum of $1,500. If it's their first offense and they blow more than double the legal limit, so 0.160 or more, then they're looking at a mandatory minimum of $2,000 fine. Now, these are minimums. They could be higher. And then with their second offense of impaired driving from alcohol, it is a mandatory minimum 30 days in jail. So no longer are we seeing people with impaired driving charges getting a fine, a higher fine, and then an even higher fine. And then maybe by their fourth or fifth impaired drive charge, they're looking at a jail term. That's not the case anymore. It's you get one chance, and if you get a second offense, you're looking at mandatory minimum jail. And I asked a judge about numbers of offenses. So if somebody received an impaired charge prior to the new laws, and they receive another impaired driving charge after the new laws, is the second offense classified as a first offense under the new laws, or is it classified as a second offense with the mandatory jail? And I was told it's classified as a second offense, whether your first offense was before or after the new laws took effect. So it is a second offense ever. And then, of course, third and subsequent offenses, again, prior or after, pre or post new laws. And then, of course, the same charges and sentences for alcohol and drug combined offenses. So first offense, mandatory minimum $1,000. Second offense is mandatory minimum 30 days in jail. And second and or third and subsequent offenses, mandatory minimum 120 days in jail. And if someone was charged with the summary offense of impaired driving because of alcohol, not causing bodily harm or death, so you took out your neighbor's fence, you're looking at a maximum of 2 years less a day in jail. Pretty hefty sentence for taking out the neighbor's fence. And for an indictable impaired driving causing no bodily harm, so you drove through a storefront where the potential to hurt somebody was pretty great, you could be looking at a maximum of 10 years in jail. Impaired driving causing bodily harm, summary convictions, so your passenger got a bloody nose from hitting the dash. You could be looking at up to 2 years less a day in jail. For an indictable offense, and those are the more serious for bodily harm, broken bones, those kinds of things, you could be looking at up to 14 years in jail. And an impaired driving by alcohol causing bodily death, maximum life in prison. The thing that people need to be aware of with alcohol impaired driving is that police officers are now able to demand a roadside screening for any lawfully stopped driver. And so even if they don't have reasonable suspicion that a driver has alcohol in their body, they could be pulled over for not wearing their seatbelt, for speeding, for anything. Tail light being not working, whatever. As long as that driver has been stopped for a lawful reason, they can be put through, they can be demanded to provide a roadside screening test. And again, they are not allowed or not legally able to call up a lawyer prior to the roadside screening. But if they fail the roadside screening and they're brought to the police detachment for further screening, at that point, once they get to the mobile testing unit or the police station, they can ask to talk to a lawyer at that point. But on the roadside, no. So I often get asked, what is classified as a standard drink, or especially now that we've got the roadside sanctions of 0.05 to 0.08. So it's, okay, so how much am I able to drink before I go over that 0.05? So when trying to estimate the blood alcohol content, they are often calculated according to standard drinks or servings over a period of time. A standard drink or serving contains 13.5 grams of alcohol. So the following is a guideline for how much beer, wine, or spirits, hard liquor, equal to a standard drink. One 12-ounce bottle of beer is a standard serving. A 5-ounce glass of wine equals 13.5 grams of alcohol, or 1.5 ounces, a 1.5 ounce shot of hard liquor also is one serving. So anytime we are talking about a standard drink or a serving, we are talking about a 12-ounce bottle of beer, 5-ounce glass of wine, or 1.5 ounce shot of hard liquor. So wine, beer, and spirits have different concentrations of alcohol. Most beers contain 5% alcohol. Wines are about 12 to 13% alcohol, and spirits can be 40% proof. Alcohol concentrations can also vary among brands and types of drinks. So what are some factors that affect blood alcohol content? A number of factors affect how quickly your blood alcohol content rises and drops. Body type, weight, and food intake at the time of drinking can all impact blood alcohol content. Body type affects the amount of blood you have. If you're lighter, you have less blood, and your blood alcohol content will be higher than a heavier person who drinks the same amount. Muscle tissue contains more blood, while fatty tissue contains more water. Since women tend to be smaller than men and have more fatty tissue, a woman who drinks as much alcohol as a man usually has a much higher blood alcohol content. So if you have a lot of body fat and you drink as much alcohol as someone of the same sex who is muscular, chances are your blood alcohol content is going to be higher. There is less blood for the alcohol to mix with, so the ratio of alcohol to blood will be higher. Some myths about sobering up. There are as many myths about how to sober up quickly as there are drinks to choose from. Drinking coffee or water, jogging, taking a shower, or taking a nap don't work. The only thing that will sober you up and lower your blood alcohol content is time. If you are over the legal limit, it will take about 6 hours for your body to get rid of all of the alcohol. It'll take that amount of time for your liver to flush it out. So here's some charts that give you a better idea of how much alcohol a person would be able to drink according to standard drinks and weight and time. All right, so, and I want you to really pay attention to the difference between men and women. So this is blood alcohol content for men in relation to time, weight, and standard Canadian drunks, Canadian drinks. So if let's go with 180 pounds. If a man drinks 2 standard drinks and they are 180 pounds over the course of 2 hours, they would likely test somewhere around 0.016. So still within the legal range. Now, if they stretched those 2 standard drinks over 3 hours, that test result would drop to 0.001, and over 4 hours, 0 across the board. However, so this chart shows three levels. The blue is the safety zone. The light peach is the warn, so immediate roadside sanctions. And the dark peach is a criminal offense. Okay, so the lighter peach color would be provincial infractions, and the darker, almost orange, would be a criminal offense. So that 180-pound man would have to drink 4 drinks over the course of 2 hours in order to blow a warn. But if they had 5 drinks in 2 hours, they would blow a fail and license suspension and criminal charge. With 4 drinks over 2 hours, it would still be a license suspension and a vehicle seizure, but no criminal charge. Okay, so just look at standard drinks over the course of 2, 3, and 4 hours for men ranging from 165 pounds up to 240. Now, pay attention to how much is in the blue, the safe zone, and that thin line of light orange or peach, and then how much is criminal compared to women. Women's safety zone is a lot smaller. So let's say that a woman, let's go 130 pounds, has 3 drinks over the course of 2 hours, they would still be, I mean, you're pushing it, you really are, because you would blow somewhere around 0.045. So you might be okay, but it's iffy. But if they have 4 drinks over 2 hours, they don't even hit the roadside, the provincial infractions. They go right from the safety zone right into a criminal offense. So women, because they tend to be smaller and less muscular, we go from our safety zone is a lot smaller. We don't have very much range for the warn section, and we go very quickly into the criminal offense. So if you're ever wondering how much somebody would be able to drink safely and still remain in the safety zone, you can just look at these 2 charts as a guideline, because again, there's other factors to consider too. If somebody is not used to drinking alcohol, it's going to affect them a lot faster than somebody who is a habitual drinker. So understanding the effects of alcohol on driving, what's the big deal? Why is the government coming down so hard on impaired drivers? We need to look at the effects of alcohol on driving. When somebody's blood alcohol concentration is at 0.02, typically it affects them with some loss of judgment, relaxation. This is where they start getting this little warm feeling. Their cheeks get a little red coloring and they start mellowing out. So there is a visible effect on them, even at 0.02. So this is what, 1 drink? You're already starting to have an effect. So the predictable effects on driving. At 0.02, there is already a decline in visual function. So you have a slightly less ability to track rapid moving targets. There's a decline in ability to perform two tasks at the same time. So your ability to multitask is affected. So your ability to divide your attention is affected. And so that's at 0.02. And it continues to go up at 0.05. Now, this is where the provincial sanctions hit. If somebody blows or registers 0.05 to 0.08, the typical effects are there is an exaggerated behavior. They may have loss of small muscle control, so some trouble focusing their eyes. There's impaired judgment, usually a good feeling, lowered alertness, and a release of inhibitions. So how this predictably affects driving: a reduction of coordination, reduced ability to track moving objects, difficulty steering, and reduced response to emergency driving situations. And so if you're ever wondering why the province has roadside sanctions, immediate roadside sanctions at 0.05 to 0.08, you just need to consider the predictable effects of alcohol on driving at different levels. And of course, the criminal level is 0.08. At this point, the typical effects are muscle coordination becomes poor. Balance, speech, vision, reaction time, and hearing are all visibly affected. Harder to detect danger. There's a significant effect on judgment, self-control, reasoning, and memory impairment. So this predictably affects driving with a loss of concentration, short-term memory loss, speed control, reduced information processing capability. So for example, signal detection, visual search, and impaired perception. And again, we continue to go up with the more alcohol we consume. Blood alcohol content at 0.10. At this point, there's a reduced ability to maintain lane position and brake appropriately. And so they're swerving in and out of lanes and not able to drive straight, never mind walk straight, but not able to drive straight or even brake. So their reaction time is significantly affected. And then at 0.15, there is substantial impairment in vehicle control, attention to driving tasks, and visual and auditory information processing. Before I actually start talking about the real total cost of impaired driving as shown on the chart here, I would also like to mention that if somebody is impaired, has failed the roadside screening, and they weren't driving, but they were in the vehicle and had possession of their keys, but they weren't driving. Let me add, they weren't driving. They can still be criminally charged for impaired driving because they were in the vehicle with the keys, and so they had the ability to start the vehicle and put that vehicle in motion. And so just merely being in the vehicle, whether you are parked or not, and have possession of the keys means that you had the means and ability to put that vehicle in motion, and you could be criminally charged for impaired driving. So the real cost, the full cost of impaired driving, legal costs, and this is just an estimate, depending on the experience of your lawyer, could range anywhere from $2,000 to $10,000 or more, depending on the severity of the charges and the length of the court process. Criminal code fine for a first offense between $1,000 and $2,000. The Planning Ahead program, first offense, $315. The Impact program, second and subsequent offenses, $925. Administrative monetary penalty for license reinstatement, and this is just an estimate, very rough estimate, $250. Towing charge, and I can promise it's a lot more now, $75, but you're probably looking at least $30 per day. Or towing charge, 75 minimum, you're probably looking at least 100. Impaired lot, it's more than $15 per day. It's more like 30 plus per day. So you're probably looking at least $450, probably closer to $1,000. Increased insurance, at least $3,000 more per year for 3 years. So you're looking at least $9,000 more over the course of 3 years for your increase in insurance. And then at least $1,500 for the ignition interlock program. So how much did that first offense impaired driving charge cost you? Oh, at minimum, let's say $15,000 upwards to at least $25,000. As well, actual costs may be higher if you include property damage, loss of employment income, and uninsured medical costs. So compare this cost to cabbing it home or calling Uber. You're looking at what, 10 to 50 bucks, depending on how far they're traveling. If you actually think ahead and have a designated driver, $0, or walking or crawling home, $0. So you do the math. And I want to leave you with this final thought. Remember, driving is a privilege, not a right. And so safeguard that privilege. If you want more information, you can go to the Safe Roads Alberta branch website. You can contact the Alberta Transportation Safety Board. We have a north and south region. Just search them on the internet. You can contact any of the Native Counselling Services of Alberta court workers across the province if you're looking for assistance. Legal Aid Alberta, if you can't afford to hire a lawyer. There's the Alberta Impaired Drivers Program for course registration, and the Driver Fitness and Monitoring Program for more information on the Ignition Interlock Program. And so hopefully you've enjoyed today's presentation and learned a lot about the new impaired driving laws in Canada and Alberta. Thanks for watching.